The results were 0.290 and 0.294.
So are you telling me
Priors, but there is a pending one out of Austin County, it appears.
is it for you? And I promise you're not going to like the way that I do.
Let's pause on that number for a second. A BAC between 0.290 and 0.294 isn't just being drunk, that's blackout level intoxication, dangerously close to alcohol poisoning. Legally, that kind of reading can elevate a standard DWI into something much more serious. But here's where the tension builds. The defendant denies drinking at all. That creates a major conflict in the courtroom. Either the numbers are telling one story, or there's something else going on medically. So what do you think? Which explanation makes more sense?
While intoxicated, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
On January 18th, 2025, the officer observed the vehicle failing to drive in a single lane on West Grand Parkway in Harris County, Texas. The defendant was swerving in and out of two lanes and came close to crashing into another vehicle.
This is the point where the case really locks in. Field sobriety tests can sometimes be argued, but breath test numbers this high carry serious weight in court. Once probable cause is established at this level, the judge's focus shifts away from debate and toward public safety. At that stage, it's less about what's being said and more about what the evidence shows. So here's the question. Should numbers alone outweigh a defendant's explanation, or is relying on hard data exactly what keeps the road safe?
In the next lane. A traffic stop was conducted, and the officer made contact with the defendant, the driver of the vehicle. The officer observed disorientation, a moderate odor of an alcoholic beverage, and slurred speech. The defendant could not provide ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Standard filter sobriety tests were conducted, HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and consented to breath. The results were 0.290 and 0.294.
So are you telling me that she had alcohol in the car while she's driving?
There was an open container on the floorboards.
Did you put any other indicators like it's cold or it's
No, Your Honor.
Ms. Keys, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand, man? I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail, man. No more PR bonds. Have you run your license, Alex?
I'll run it right now, Your Honor.
Please. And any prior DWIs?
There are no priors, but there is a pending one out of Austin County, it appears.
Is it? She has a pending DWI in Austin County?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine every single time. I am now going to put an ankle monitor on you so I know that you're not consuming, and I'm also giving you a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor. Stop. I don't want you to talk about the case. I can provide you a lawyer today, but if they're telling me that you have an open DWI and now you picked up another one, I have a big problem with that. I was going to provide you a lawyer today, ma'am, if you would like, a court-appointed lawyer. Did you want a court-appointed lawyer? I will provide you a lawyer today. Ms. Keys, if you have a problem with alcohol, I'm giving you the opportunity now to address it on your own. If you do not, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand, ma'am?
Yes.
I'm going to do everything in my power to protect my public at all cost. Every single day, someone dies from a DWI in our county. I need you to fill out an application for me and, or you know what, hold on a second, maybe not. No. Vic, I have an application on file already. So if you just want to appoint her a lawyer, I'm going to have you sign a receipt with Victoria. You will meet with Felicia for your bond conditions. And after that, we'll have you take a seat while I'm your lawyer. I'm going to have you sign a reset. After that, you'll get with Felicia for your bond conditions. After that, I'll have you take a seat while I find your lawyer. Please.
No driving affidavit?
Oh, yeah, no driving affidavit. Right.
I spoke with her again. She said that she needed to reach out to her dad and brother to see a time that would work for him to come.
Where is the car?
The
Where?
car is at the property at,
Is it in the, like, you know, apartment complexes have outlying lots. They have lots that are inside of a gate. You need a code to get in to get the car. She didn't say where the car is?
I know the address of where the car is. I don't know exactly what type of property it is.
Can we do an in run around this, Judge? If you'll allow exemption for me to do all the, middlemaning, my client will go and pick up the vehicle. I'll get it. I'll talk to them and
Okay.
get it somewhere.
And you're an officer of the court. I trust you. You know, find out where the car is exactly so he knows exactly where to go get it. Hopefully it's not in a complicated place where he's going to have to talk to them because I don't want him to talk to them.
Of course, I
You know?
will be communicating with them about anything from him, just for him to
Yeah.
get the.
So let them know that he's not to talk to them. If he goes and tries to talk to them, I'm putting him in jail, right?
Yes, Judge.
Just to get the car, that's it. And
I
get the middleman, right? Yeah, of course you can. I mean, you're the go-between.
Yes, Judge.
Okay.
Okay,
Thank you, Your Honor.
for sure.
Will we need to redraft that? Commissioner can just finish on it.
Let me see what it says. Hold on.
But technically, if I'm doing it, I guess it's still no contact.
So what I'm going to do is I'm going to edit this to say this. It says, do we know what day he wants to go back?
I don't know, Judge, I'll have to sort all that. That's why I'm saying there's gonna be some contact about, is there a gate code? Where is it? When? So I need to,
Because he's got 3 days from the date of that letter, right? When was that letter?
I think it said until the 25th.
Okay, just remind me.
Making those tomorrow.
Okay, so I'm going to put here, defendant has until 1:25 to go get his car from the above listed address. Defendant is not to have any contact with the complaining witnesses and no weapons as well. So he's going to be the middleman to figure out where that car is for you to get it. You get it and you go. Don't dilly-dally. Don't try to talk to them. If someone comes, just get it and go. Make sure you have everything with you. They're probably going to maybe want insurance. Don't bring an insurance card. You know, it's like when you go pick up your card at your car at like an impound lot. You need your insurance card. If you don't have insurance, they're not going to give it to you. Make sure you come with the keys. You've got your insurance card, everything, so that you know. You understand?
Yes, sir.
Okay. All right. We'll have you sign this. So you know what you can and can't do.
Yes, sir.
All right. Okay, good. Come up, sign it. We'll let you go.
Thank you.
Okay. And thank you,
Thank you for your patience.
JP. No. Thank you.
All right, Judge, next is page 20. Sanford, come on up.
You were Jessica Sanford. Ms. Sanford, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On September 29th, 2023, officer was dispatched to a disturbance call in Harris County, Texas, and met with the complainant who stated he asked the defendant to leave his apartment multiple times, but she would not comply. The complainant had video footage of the defendant refusing to leave and mentioning something about darkness inside of him. And the complainant and the defendant were in a relationship, but the complainant had ended things earlier that day. The defendant locked the complainant out of his apartment, and the complainant showed officers an injury on the back of his neck that appeared to be nail scratches. The defendant barricaded herself in the apartment, refusing to leave. So in this case, Your Honor, the injury caused by the defendant, according to the complainant, would be the nail scratches on the back of his neck that he showed the
You
officer.
say you never told me that an officer said this, that he told this to an officer?
Complainant just showed an officer an injury on the back of his neck that appeared to be nail scratches. Let me read the full DIMS, Your Honor, and see if he mentioned something else.
We don't work on hunches.
Yes, Judge.
I never heard anything that don't, please.
So the full DIMS reads that the complainant advised of an injury he had on the back of his neck area that appeared to be nail scratches done by the defendant with their hands, causing the complainant to feel pain.
That's
Yes, Judge. And I apologize for
okay. I just want to make sure that we're
Yes, Judge.
in the up and up. Ms. Sanford, I'm going to find that there's probable cause to go forward with your case. Do we know whether he wants to have contact with her or not? I know that you want to talk. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. Now's not the time. You will have the opportunity to fight. I promise.
I don't want to fight, sir.
Okay, don't say anything. I know, please. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. Just don't.
We've attempted, but we're unable to get a hold of her at this time.
Okay, so tell me, Ms. Sanford, are you working at this time? I only want to know, are you working?
I haven't been able to because since I've been arrested, like
Stop.
I haven't been able to get a,
I will provide you a lawyer today. I don't want you to say anything. I'm going to give you a lawyer. You can tell your side to the lawyer. Lawyers can talk to the DAs for you. But I've got so many people here. I mean, all these people will be witness to whatever you say, and they'll use it against you to prove guilt, okay? So just hang tight. Give me 20 minutes. I'll give you a lawyer. You can tell your side to the lawyer, okay? I want you to understand, though, I don't want you to have contact with this person because I don't know if they want to have contact with you. They've been unable to reach him. Until that we know that she or he wants to have contact with you, don't. Trust me, I'm trying to help you, okay? I promise. We're not here to do anything bad. I'm going to help you as much as I can, okay? But I need you to be patient with me, all right? Rome wasn't built in a day. Just be a little patient. Let me get you a lawyer and you can tell your side to the lawyer, okay? Please. All right. So what I'm going to have you do now, I'll have you sign a reset. Just take a seat in the jury box. Let me find you someone here momentarily, okay? Do you have any tissues?
Just have paper towels.
Well, no contact, no weapons for that.
Judge.
Right side, sit one more time. Right there. Your Honor, here in a second, you're gonna have Mr. Webb, Mr. Rubio, and Mr. Gerard.
Webb.
In that order,
Okay.
we're all for three.
Webb, Rubio, and Gerard. Okay.
They're all time served now, appointed for dog center. I think it's two.
Yeah. So Lori has all of them?
Mm-hmm.
All right. Good morning, gentlemen. All you guys have picked up criminal cases and you all have worked out agreements with the state and with defense to end up pleading guilty to these cases. You are Mr. Webb. Mr. Webb, you stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. Mr. Rubio, you stand charged with the offense of criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. And Mr. Gerard, you picked up a number of cases while you have been on bond. However, it looks like you have worked out an agreement You have a total of 4 cases, and it looks like they are going to dismiss 3 of them in exchange for your plea on one of them, which is the theft, where you're facing up to 6 months in jail and or a $2,000 fine. You now have at least 2 on your record. So what happens on the next one? Right. Instead of days, you were looking at years. So no matter a pack of gum, pack of smokes, you could be looking at years in jail. Do you understand? All of you are giving up valuable rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record and you cannot take it off ever again. Is this what you guys want to do?
Yes, sir.
Is this what you want to do, Mr. Rubio?
Answer out loud.
Yes, I don't know.
Yes, sir.
Do you want to do this? Yes or no?
I don't know. I'm not sure. I don't do. Yes.
Do you know what's going on now?
Yeah. Not really.
You were charged with a criminal offense. You've worked out a plea bargain agreement that you want to plead guilty to a criminal trespass. If you don't want to, you don't have to. We can do something else. If you need more help, we can give you time to get any kind of help that you need.
Okay.
What would you like to do, Mr. Rubio?
I'm not sure. I don't know. I've never been here before.
Okay, so let's give you a second. I'll have you talk to Lori. You guys can work out what you guys want to do. If you need more time, that's okay. Mr. Webb, is this what you want to do as well?
Yeah.
So-
No, I'm gonna, sir, I mean, plead guilty.
Plead guilty.
Yep, so they've offered you 32 days in jail. We'll give you credit for the 32 days that you've done. So basically, it's a wash. You get out today, but understand from now on, it's a minimum of 30 days in jail.
Right.
How do you plead to the offense of criminal trespass, sir?
Guilty.
I'll find you guilty and I'm going to send it to you to the agreement. Good luck to you, sir. Mr. Gerard, you've worked out an agreement. It's 5 days in jail, credit for the 5 that you've done. How do you plead to the offense, sir?
I'll plead guilty, sir.
Sir, I'll find you guilty. I will follow the agreement. If it's enhanced, it'll be abandoned. Mr. Rubio, if you want more time, we'll give you more time. You can come back and let us know what you want to do. Okay?
Yeah.
All right, gentlemen, go ahead. This report.
Careful, man.
Mr. Gerard, can you please go?
Come on.
Go.
No, no, that way it's easier for them.
Okay.
Yeah, let's hold off. We'll wait to see if they,
Otherwise, I don't.
which is the theft that we're going on? Is it the, on Gerard, is it 6-2? So 6-1 is being dismissed.
The one page 29 is getting flag. Page 28 is getting.
Yeah, okay, got it. If web is enhanced, it needs to be abandoned as well. If web is enhanced, it's got to be abandoned as well. I didn't see whether it was or not. Marcos, you want to talk to me already?
Yes, Judge.
Hey.
Approaching on Mr. Miguel Moreno, this is an FSGI judge. The state has spoken with AT&T, who is the owner of the other vehicle. There's an estimate of about $26,000. Does not necessarily, I don't think that's accurate, to be honest with you. They have an estimate of 26,000. The state has reached out again to see whether that's what was actually paid by AT&T, which I'd be very surprised.
No, of course not. No. They're loaded with insurance for these
Correct.
kinds of.
So what
No?
the whole point was, what I'm trying to do is have him pay some sort of restitution and let it go. And
Sure.
I think the state's
Yeah, absolutely.
inclined, but they just need to find out, what happened, whether repairs were
Yes,
done.
Judge, we just need to confirm whether the vehicle's been repaired and what the actual amount paid by.
Problem is how do you do that, right? Because I know that you guys had a problem even trying to get a hold of anyone at AT&T to get this kind of information.
Well, Mackenzie's reached out and she sent an email and they said they would return some sort of response to her, but as of now, they have not.
So why don't
yet.
we set it for Monday?
Okay.
Hopefully, you can try to get a response. Good luck. I know that it's been an issue in the past.
We can go from there.
Yeah.
Okay, sounds good, Judge. Thank you.